A very good evening to all of you. Welcome to the Daksh Annual Constitution Day lecture. This lecture is a part of a series that Daksh has been running since its inception to deepen the understanding of the Constitution and reflect on the intersection of constitutional ideals with our everyday problems and issues with the justice system and public institutions. Recently, as most of you are aware, there's been a lot of debate about the relevance of the Constitution and its supposed colonial legacy. I remember as a young student growing up in conflict-ridden Jammu and Kashmir, studying about the preamble as an 11-year-old. This was the first time I had heard about the Constitution. At that age, the values of justice, liberty, and fraternity seemed a little abstract, but equality was what intrigued me. And I wondered, are we really equal as Indians? Am I equal to the boys in my class? Can I play football with them? Can I aspire to be a fighter pilot like they can? Today, several decades later, I am still fascinated by the Constitution and grateful that this document has survived various challenges and tumultuous decades of our republic. This year, I'm delighted to welcome Justice S. Muralidhar to deliver Daksh's Constitution Day lecture on the topic, Appearing in Virtual Mode, Technology and Indian Courts in the 21st Century. It's cliched to say that Justice Muralidhar doesn't require an introduction, but I'll just go ahead and do a short introduction for those of you who are not familiar with him. Justice S. Muralidhar was the Chief Justice of the Odisha High Court between January 2021 and August 2023. During his 17-year-long tenure in the judiciary, he also served as a judge of the Punjab and Haryana High Court and the Delhi High Court. He is one of the most courageous judges we have had in recent times, and his commitment to access to justice for all shines through his work as a judge and as a lawyer. My seniors from law school have described to me how he would practice from a blue mini Omnivan parked in the Supreme Court parking lot. For those of you who are not familiar with an Omnivan, it is the precursor to an SUV, a largish vehicle in which extended Indian families would be packed in. From his days as a public interest lawyer to his career as a judge, Justice Muralidhar has consistently demonstrated an unwavering commitment to justice. He has shouldered these challenges with amazing grace and has always greeted us with a warm smile whenever we've interacted with him. Let me not take any more of your time and welcome Justice Muralidhar to the stage.
Thank you, Leah. A very warm good evening to everyone. A small correction, a white Omnivan by Chinese whispers has become blue. I'm very happy to be here talking to you about the courts and technology. In fact, the choice of the topic was Daksh's. So I asked them to give me a choice of 3 topics, and I said, let me choose one, and this was there. And I'm still very close to this topic, so I said, let me also showcase what happened in Odisha in those 2.5 years. So we'll begin at the beginning. One, I just want to make some prefatory remarks. One is all the changes that have happened in the judiciary through technology have been judge-driven. And I want to make this point, and I'll develop on this later. The 2 major players when you talk of a judicial system, of course, lawyers and judges. So this demand for the increased efficiency of courts through technology has not come from the lawyers for some reason. Even today, while judges have got onto the system of paperless courts, for instance, not all lawyers are paperless. In fact, many of them are not. And we'll try and understand why that is so. So that is one of the prefatory remarks I want to make. Second is that although we like to talk of independence of the judiciary, when it comes to funding this entire project, technology project, and it's in 3 phases, phases 1, 2, and now in the midst of, it's the beginning of phase 3, the funding has come only from the governments. The majority of the funding is from the central government, and a portion of it comes from the state government. So the judiciary is not totally independent on the control of finances for this scale of a project. The third is, and this is not peculiar to the judiciary, that whether it comes to hardware or software, neither is the government nor, of course, the judiciary is in control of the rapid changes in technology. There's a need to constantly adapt to the changed, better versions of either hardware or software. This is a great dependency on suppliers of hardware and software who are not within quotes, unquotes, jurisdiction of the courts. That is, they're not necessarily answerable to the court system or even to the governments. There are major multinational players in the area of software and hardware, and this is something that we should bear in mind when we talk of the functioning of the courts. With those three prefatory remarks, let me start at the very beginning. We go back to, not of course the beginning of the 21st century, we go back to the last part of the 20th century. Those in the audience who may not know what is a caveat, I should just tell you that A versus B in the first court results in A winning and B losing. A anticipates B going in appeal to the next court, so A files a caveat in that appellate court so that no order is passed by the appellate court without hearing A. This is basically what a caveat is. So the very first instance where technology was used to check whether a caveat has been filed, because a smart lawyer with sharp practice might try and get an order from the appellate court without the other side, the winning side in the lower court, knowing. And the other side would be caught unawares. And this caveat matching, they call it caveat matching, was a very important function which this technology was used for. And this was way back in 1989. We've come a long way from that. I'll skip the details of how many courts got computerized. What we must remember is that the first phase began only in 2005. And it was declared as a mission board project in June 2006. And the financial sanction for a project which was approved in October 2005 happened almost 2 years later in 2007. So this also shows when the government is part of all of this, whether it deserves the kind of priority, it gets the priority it deserves. And this has been another running theme, where there's a lot of dependence on how soon government releases funds for utilization by the judiciary for its projects. Anyway, in the first phase of the project, the emphasis was on courts and functioning of courts, and not so much as services to the litigants. For instance, you would have the cause lists. We call the cause list basically a list of cases that are listed before a court for hearing. And that is published as what is called a cause list. And these are all jargons. I'm afraid I'll be using some jargon during the course of this lecture, although Daksh has requested me to try and avoid as much jargon as possible. So those were computer generated. And then, like I said, caveat matching was done through computers. The scheduling of cases in terms of categorization of cases and categorizing and scheduling those cases before benches, computer used for all of this. And just like in all other fields, and we ourselves have done it, all the production of documents, that is the word processing functions, were substituted, typewriters were substituted with computers. So this was actually the first phase. There was very little data analytics. There was very little understanding of data generated through the use of computers. That had to await the second phase, which began in as late as 2015. The first phase continued for 8 years, up to 2015, where 15,000 courts had computers in the court premises, printers in the court premises, but there was not connectivity to the internet at that stage. It happened during the second phase. The second phase was approved in 2015, and in the implementation of phase 2, several milestones were achieved, and I'll just come to that in a minute. The third phase, which is now in September 2023, which was approved, has just begun. And the third phase is supposed to have the ecosystem approach. I'll talk about it later. The finances for these phases, first phase had a financing of around 640 crores, all granted by the central government. The second phase involved about 1,700 crores, again funded by the central government. The third phase, they've announced that they're going to provide 7,000 crores for funding the entire phase 3 rollout. I'll just talk briefly about what computerization of courts envisages through the e-court project. In the first phase, the control was with the National Informatics Center. That was supposed to be the implementing agency. So all the ideas came through it, And very early on, a decision was taken to adopt what is called free and open source software, FOSS. Now, whether this was a good thing or not is up for debate. I know some of the courts could progress faster than the others in terms of computerization because they did not go for FOSS. Whereas even in the Vision 3 document, it says that we must stick with FOSS, which has got its own advantages. They also came up with what is called a core and periphery model. Now there's a centralization of this entire project of computerization of courts in the E-Committee of the Supreme Court. E-Committee is basically electronic mode of functioning of courts. It's a committee set up by the Chief Justice of India. The present Chief Justice of India was himself chair of the E-Committee even before he became the Chief Justice of India. He continues to be the chair of the E-Committee even today. It comprises of basically judges supported by registrars who have a good knowledge, working knowledge of computers, and representatives of the government. That's what the E-Committee is about. In the second phase, the implementation of this entire project was left in the hands of the high courts rather than the government. And the core periphery model was developed, thinking that there will be one core model and which will be used by all the high courts and all the district courts. And wherever they needed to customize for their particular needs, they would be allowed to do, and that was called the periphery changes. Being part of the computer committee of the Delhi High Court for about 8 years, I knew we had great problems in developing this periphery around the core. And there some of the core functions actually needed to be tweaked, and we were unable to do it because of this core periphery system, which was developed actually it was developed by CDAC in Pune, and that was the model that was put forth for the entire judiciary. So in phase one, we had the NIC being the implementing agency and the Department of Justice being responsible for strategic direction. Whereas in phase two, as I mentioned, high courts became the implementing agency, and E-Committee of the Supreme Court provided policy, planning, strategic direction, and guidance. So what happened was, while in phase one, we were creating systems for the courts and the judiciary in general, and services were provided offline. In the second phase, we created what Daksh would call, or other agencies like Daksh would call, as monolithic systems. Like, for instance, we had the National Judicial Data Grid. I think I'm slipping back into jargon. Basically, what this does is collates all the information on pendency of cases in every court in the country and makes it accessible in a place on the net for anyone to view and to read and to understand. So typically, if you wanted to find out what is the pendency of, let's say, the district court in Nanded in Maharashtra, you could go on this National Judicial Data Grid website and drill down. I mean, this is again a computer jargon. Drill down to that information about that court. And within the district court, if you wanted to go to the court of the Chief Judicial Magistrate, you could go to that court and to see what are the cases pending in that court, how long has it been pending for, what are the orders passed in that court. You may not get access to the pleadings, that is the petition, the reply, or the evidence. You may not get access to that, but you will get access to the listings of the case, the orders passed in the case, and how long it's been pending. So today, using this National Judicial Data Grid, you can do some amount of data analytics. Let's take the instance of the Chief Judicial Magistrate in Nanded. How quickly is he or she able to dispose of a case, let's say, of cheating under Section 420 IPC? You can compare that court with a similar court in Kerala, and you can find out whether they function at the same degree of efficiency. If you find differences, you will then get down to analyzing why it is so, how many adjournments were granted by this court as compared to that court, who sought those adjournments. That kind of analysis has been done by agencies, including Daksh. It's been done by Vidhi. It's been done by certain other agencies as well, and they've been bringing out reports on pendency and arrears in courts. So the second phase of computerization helped with this kind of data analytics, and that was built upon in the second phase to also have systems that talked to each other. For instance, in the second phase, we have seen that you can pay court fees. That is the charges that a litigant pays for filing a case. There are different court fees that you pay for different kinds of petitions. So instead of actually going and purchasing court fee using cash, you actually can pay it through a card now or even pay online. So this e-payment of court fees means that the court system has to talk to the banking system. So to that extent, there is some kind of an interoperability here that is happening in a limited sphere. We have the case information system developed, which is another monolithic system, which others can use. But basically, you have to engage with each of these systems individually, and you can't have these systems talk to each other, which is what they want to do in the Vision 3 document, which has been rolled out in September 2023. The other important comment to make was that it is the judiciary which is controlling all of this. If something goes wrong, something is found lacking, the decision for that has to be taken by the E-Committee first and by the high courts, which are implementing agencies. Now, all the judges who are there in these committees should have some working knowledge of computers, of technology. They have not been trained for it. I think the Indian judiciary was very fortunate that at various points in time, it had judges who had a kind of inclination to learn more about computers, to start using computers themselves, who sat on these committees and therefore could carry this project forward. If I can mention a few of them, Justice Madan Lokur, he headed the E-Committee in the Supreme Court for a number of years, but also the Delhi High Court, he chaired the committee, computer committee, of which I was a member. Then you had Justice Badr Ahmed, who was in the computer committee in the High Court of Delhi for many years, who had a great vision for computerization, who also had the capacity to write software programs as a lawyer himself. So it's just that we got lucky with some of the judges in the system themselves being computer savvy, and somebody like me working with them, I could learn a lot through that association. And some of us are therefore not hesitant to start using technology for our own work. So it is not surprising that in this second phase, the first paperless courts in the country started working in the Delhi High Court. The first ever paperless court was Justice Ravindra Bhatt's when he was in the Delhi High Court. I think it was in February of 2010. And then I became a paperless court in the Delhi High Court 2 months later. And we continued as paperless courts. Basically, whatever cases I was hearing in that roster is again a technical legal jargon. Basically, the types of cases I was hearing, all those case papers would get scanned. They would get presented to me in what is called a soft copy. I would read it on a monitor on my dais. I would use a digital pen to make my notes on the file. And I would even be able to access reported judgments of the Supreme Court and the High Courts on the monitor itself, because the software for that would also be uploaded on that monitor. So basically, I was working in a paperless mode. The lawyers need not necessarily work in the paperless mode. We did not make it compulsory for the lawyers. And I think it's a good strategy not to make anything compulsory, because it meets very stiff resistance. Some of the lawyers were incentivized to adopt this paperless mode because we would give them free soft copies of the entire case file. This entire case file would be bookmarked. For those who don't understand the word bookmarked, it basically means if I have a volume like this and I want to go to this page, in physical form, I would put a sticker here, a post-it, right? Computer does it now. If you bookmark, you have software which bookmarks your entire file. So if you want to read the evidence of, let's say, PW6, it will be bookmarked saying evidence of PW6. You click on that, and it straight away takes you to that evidence. You're not wasting time sifting through the file. So likewise, every important part of that file is already bookmarked for you to use. So sometimes the judge is quicker in reaching the particular page of the file than the lawyer is. So the more you get to use it, the easier it becomes, just like our mobile phones. So the way I would sell it to my colleagues in the Delhi High Court is to use the example of the mobile phone, saying that when the mobile phone came into the market, none of you said, like, I can't use the mobile phone unless I'm giving coaching classes, right? When the analog phone became the touch phone and smartphone, we didn't say, no, we are not going to buy these touch phones. We, in fact, went standing in queues outside the Apple stores to get the latest phone because we wanted to have it. And we were not deterred with the fact that we had to learn something. We could learn it from our colleagues, we could learn it from our children, learn it from our grandchildren. So we didn't have a mental block about using a mobile phone. I used to tell them, therefore, similarly, reading paper on a screen should not deter you. But I think there is a valid point being made here, even today, but by some lawyers and even judges who say my thoughts don't flow unless I touch the paper. My thoughts don't flow unless the pen, the tip of the pen touches the paper. I think it's a valid point that they're making. And I mean, there are no easy answers to it. Only that when you start reading on the screen, it makes it much easier as a judge because you're not deterred by the size of the file, whether it's a 10,000 page file or a 500-page file. When you're a paperless court, it doesn't matter. But when you're operating in physical mode and the court master keeps on your desk a 10,000-page file, you're mentally already thinking, how can I have this case adjourned? And some lawyers strategically use that. They say, tell the court master, better keep all the volumes on the dais of the judge. And usually the senior advocate will say the flourish, my lords, the records will be in 4 or 5 trunks. And the judge looks at those trunks and he says, my God, this will hold up my whole week. I can't possibly take up this case. But in a paperless mode, there's no such psychological stress on the judge, although there may be on the lawyer. So these are small things that I found useful as a paperless court. I must also share with you what happened in the Odisha High Court before I get on to the more particular details. When you operate in a hybrid mode, which is what is happening post-COVID in most courts in the country, you basically can have lawyers appear online, just like a Zoom call or a Skype call, and you can also have them share, whether it's a presentation or a citation or a video clip, you can have them share on the screen. I took this a step further. We were dealing with illegal shrimp farms in the coast of Odisha. Every third day, I would get a complaint by someone saying, despite your orders saying that there should be a dismantling of illegal shrimp farms, a new one is coming up every day. Basically, what would happen is I would pass an order, they would dismantle one shrimp farm, and by the time that enforcement team left, 2 others would come up overnight. So this was becoming a kind of a nightmare. So I was dealing with one such complaint where they were saying, despite your order just passed last week, look, this shrimp farm has not been dismantled. So what I ordered was somebody will stand with his mobile phone at the spot and give me a real-time video of what the ground situation looks like. So in the court, on the screen with all lawyers and the collectors of 3 districts, Puri, Ganjam and Kendrapada watching, we could actually go on the coastline and see those shrimp farms which had come up overnight. So then there was no question of an argument saying, no, what he's saying is not true, what I'm saying is only true. Argument stopped. Another instance, a slum was relocated in Cuttack to a colony, and they were complaining that the sanitation in the slum was, in the colony was despicable. So typically the municipal corporation lawyer said, let me take instructions. I gave him a week. He again said, no, let me file an affidavit. I said, let's stop all this. Tomorrow morning, 10:30, 2 of your municipal corporation officers will be in the spot, and they will walk through the colony with their mobile phone, and we'll see what is happening. Which is what happened. And the minute the man turned the corner, because the first street was all very clean, neat, all painted, I said, walk on and turn to the right. He turned to the right, and there was that huge garbage, which they hurriedly, kind of pushed to the one corner. All arguments stopped. So I then realized that you can use technology to cut through all the maze of, contradictory facts with the court not knowing what the reality on the ground is. I've often felt, even in public interest litigation, if the court actually went to the spot, would it make a difference? And I think it would. I was appearing for many years for victims of the Bhopal gas disaster, for many years for the tribals in the Narmada Valley who were displaced, and much of the time of the court was consumed in one side asserting one fact and the other side denying it. And I really felt if the court was actually physically located there, it would make such a huge difference. Anyway, that didn't come to happen, but I think technology gives us that possibility, that positive possibility of cutting through the maze of contradictory facts. So just to come back to the milestones, I've spoken about the NGDG. People have developed apps. Today, at the touch of a button, you can get to know in the court in which you are supposed to appear, whether it's Delhi High Court or the Odisha High Court. And today, as a hybrid hearing, I don't know whether many of you know it, a typical senior lawyer, a busy senior lawyer, will have 3 or 4 screens in front of him. So he will appear before the Odisha High Court here, he'll appear before the Delhi High Court here, he'll appear before the Supreme Court here. And of course, the meter is down for each of them. So that is a possibility today. And that wasn't thought of when even I was in the Delhi High Court. Similarly, litigants can watch what is happening in court, whether the lawyer is actually prepared in the case, whether he or she said the right thing or not. And lawyers have to be on the watch about what they are doing in the court. They better be well prepared. They better not make statements which is contradictory to the instructions given by the client. So it's putting everyone on a higher watch. So we have, as part of all of this has happened in the phase 2, this national service and tracking of electronic processes. Now, process is again a legal jargon. Okay. Basically, A has filed a case against B. The court is asking B, what do you have to say to what A has said in his petition? So the court basically issues notice to party B saying, let us have your response. This serving of notice is a big step in every case. And if A has an interim stay in his favor, it serves A not to make sure that B is not served, so that the stay keeps lingering on in court. So the service of notice on B would mean not only serving a notice from the court, but serving on B a copy of the petition. And this is one of what is called the choke points in the progress of a case. Many cases don't progress beyond the stage because the service of notice is not complete. So the earlier reports from the process server would be, I went there, door locked. I went there, person not found. I went there, the person who opened the door refused to receive the notice. All kinds of, standard replies left without a forwarding address. This is all very common. Now, we don't know whether that's actually happened or not. If B is smart enough and is prepared to make the process server very happy, he can write whatever B wants him to write on that report. And that service will never be affected. This end step, this national service and tracking, basically gives this process service a mobile phone, which can capture a video of the actual service of notice or the pasting of the notice, so that arguments on that is cut short, and sends a report real time to the court. It can be just like you have the tracking of courier parcels or speed post parcels. You now have a tracking mechanism by which you can know, sitting in the court, whether this was served or not. But this is only one part of the problem. The other part of the problem is actually getting a copy of that petition. In the physical processes, that petition would be put in an envelope, which would be sealed and delivered to the person receiving it. Let's say I'm a respondent in a matrimonial litigation. There are many private details in that petition which I don't want the world to know, right? And I therefore can't have an open cover sent. So people would ask, why can't you send it by an email attachment? An email attachment is open to be seen by everyone who can enter the system and see it. Even if it is protected by a password, there's no guarantee that it can't be seen. And it is presuming that the person who receives it first has an email ID. You'd be surprised to note that there are many Indians who don't have an email ID. There are many Indians who don't have access to computers. There are many Indians who do not know how to read an attached file. So the reality is, if the person who is supposed to receive the notice is in a remote village in Assam, he can't be expected to have access to this attached document on an email. So we really have a problem on this last part of the process serving, which is actually serving a copy of the petition. I'm just flagging this when we comment on what is proposed in the phase 3 document. We have virtual courts. You'll see that in Odisha. We have automated emails. Basically, what is the next date of hearing? In the physical form, you went to the court system. You enter the court. It's all, completely a maze for anybody. I've had highly literate person, highly informed persons, completely lost in the maze of courts. Just as an anecdote, just to lighten up the mood, it's the Punjab and Haryana High Court, and typically the lawyers are on strike. So one of their colleagues has been caught for a traffic violation. He's roughed up the policeman who dared stop him. So the entire bar is on strike. Now this old Sadaji is waiting in the Chief Justice's court, and he's tired of waiting, so he decides to go up and argue the case himself. So he says, Janab, and starts speaking. When one of the judges says, हमें समझ में नहीं आ रहा है, आप वकील रख लो. So the Sadaji says, कमाल है, समझ आपको नहीं आ रहा है और मुझे वकील रखना है. So for many a litigant, this is a maze. It's the jargon being spoken, and somebody gets up and murmurs something, the judge murmurs something, and the case is over. And I've had so many occasions, even as a lawyer, the bewildered look on the client's face saying, what happened? What happened? So that continues even till today. So this navigating this maze, whether that becomes easier with these mechanisms is something that we need to discuss. Where sitting in the confines of a house, a litigant can actually watch what is happening. And many of our live streaming hearings today are available. Like you want to know what I did on, let's say, 1st August in the Odisha High Court, you can go to the YouTube and type out 1st August live streaming, Chief Justice's Court, you'll get to know. So today the litigant is able to have better knowledge on what is actually happening in court. This is only one small part of the problem, though, a significant one. So phase 3, the organization which is hosting today's lecture was part of drawing up this phase 3 document, and not alone. 2 other organizations, Vidhi and Agami, also helped in drawing up this document. And it proposes, and this is what I've said, this financial outlay of 7,210 crores. For scanning, digitization, they've set apart more than 2,000 crores. For cloud infrastructure, 1,205 crores. For additional hardware, 643 crores. Infrastructure, 426 crores. And virtual courts, 413 crores. But the devil is, of course, in the detail. People shouldn't feel elated, 7,000 crores is made available to the judiciary. Getting those 7,000 crores is probably going to take a long time. After getting that 7,000 crores, utilizing that 7,000 crores is the real challenge. Typically, the government gives you 100 crores. Some judges sit around in a committee and have to decide to spend that 100 crores. They float a tender for buying computers. The bids are not good enough. One bidding process takes 3 months. They have to re-tender the whole thing. That takes another 3 months. February of the year has arrived. You have to return funds by March. You are expecting judges to suddenly become people savvy in technology, knowing to choose which is the best computer, which will work well for you, which is the most competitive in terms of pricing. Judges don't have that background training or knowledge. But there's a huge burden on the judiciary to do all this, which is why the Vision 3 document provides an alternative, which again, we will discuss. Basically, what this Vision 3 document does is, it advocates what is called an ecosystem approach. It says that the solutions to the problems should emerge rapidly from the ecosystem, rather than separately working on solutions by treating it in a separate module. It talks of application programming interfaces. It compares this to the development of digital payment apps, which have proliferated, and thinks that this could be one solution to developing apps for different kinds of problems, which can increase transparency and accountability. It wants to treat this entire performing of the functioning of a court, the judging itself. It wants to see it not as a sovereign function, but as a service. So what is this altered vision of judging as a service? What does that entail is what we have to discuss when we look at the phase 3 vision document. It wants a greater role for private players. It says make available all the judicial data that you're gathering. You, of course, set down norms, privacy norms, you have governance structures, but make it available for market players to enter to develop solutions for you. And whether we want to do this, whether it's safe to do it, is something that we all need to debate about. So I'm going to take a small detour now and go back to my favorite state now, Odisha. Odisha has 30 districts. it has 25% tribal population. And we were functioning from this place called Cuttack as a high court. Odisha is one of those states where the high court is not located in the capital of the state. Bhubaneswar is the capital, but Cuttack has always remained the seat of the high court. And lawyers in Cuttack are very touchy about even the vaguest suggestion that the high court should move to Bhubaneswar. They've litigated on the judicial side. They've got a judgment on the judicial side saying it will not move from Cuttack. So that's where it is. And among the various measures, and let's list them out quickly. First is this record room digitization center, where we digitized the old records of the Odisha High Court. There were 11 lakh records to be digitized. But we didn't stop with that. We've been digitizing even the current records. And we're receiving the new records only in soft form. If somebody brings us a hard copy, we receive it and quickly scan it ourselves and consume it, as they say in technology jargon, consume it in the system as a soft copy. We've digitized the administrative files. The office of the Chief Justice of the Odisha High Court is completely paperless. And the waiting time for clearing of a file is between 2 and 5 minutes. So that is what it had come down to. No question of a registrar waiting outside the Chief Justice's chamber for 3 hours and 4 hours with a huge bunch of files. We have paperless committees. We have paperless courts, not just in the High Court, but in the districts as well. Then we have inspection of case records, which happens in all high courts in physical form. We've offered the lawyers inspection in soft form, which they're finding very useful. We have e-payments, of course. We also have the digitization of lower court records. For those who are not lawyers in the audience, when a petition is filed in a high court challenging an order of a district court or a court below the district court, the lawyer will not ask straight away for stay of the proceedings. The lawyer will simply suggest to the high court, please call for the records of the case. All right. What it effectively means that the physical record from the trial court has traveled all the way to the high court, which actually means a stay of all proceedings. Now, when the trial court, they call out the case, there is no case record. The judge says, where is the record? His court clerk says, no, it's been called by the high court. Till such time the high court decides that case, the trial cannot proceed to the matter. So this just one sentence saying call for the records means that the case in the trial court has come to an end. Now, the smart lawyer in the high court knows that each high court has lakhs of cases. If this one case doesn't get listed, nobody's going to notice, right? So it's easy to make sure that the case remains in the high court like this, with this one sentence saying call for the records. For 10 years and 15 years, there's no progress of the case. In fact, one comment I have of this Vision 3 document is not acknowledging the role of lawyers in the entire system. The lawyers are a huge player in the system. They know how to delay cases. They know how to accelerate cases. So they know, as you say, to play the game. So Mark Galanter, a senior law professor from Wisconsin University, has done remarkable study of the Indian system for more than 50 years. He has written a wonderful paper called Why the Haves Come Out Ahead. So he divides litigants into one-shotters and repeat players. If you take the instance of motor vehicle accident, the insurance company will be a repeat player. The accident victim would be a one-shotter. The one-shotter's capacity to litigate in court is so much reduced in comparison with the repeat player's capacity to litigate. Tobacco companies in the US were repeat players. Victims of tobacco use were one-shotters. So the repeat players have the capacity to go on litigating till they turn the law in their favor. And that's therefore a remarkable paper which needs to be read by everyone. It's available on the net. Mark Galanter, Why the Haves Come Out Ahead. So we cut through this one step of the lower court record getting stuck in the high court by saying all these records will be digitized and sent back, which we did. And we issued instructions that hereafter, if any judge calls for a record, you will only send the soft copy and not the hard copy. This way we made sure that the case is progressed in the trial court. We went with hybrid hearings, and we've continued with the hybrid hearings in the High Court. We have different kinds of virtual courts. What the Vision 3 document talks of as virtual court is for traffic offenses and some small petty offenses where you can appear before a judge in virtual mode and have the fine paid or settled. When we talk of virtual courts, we're talking of entire trial taking place virtually. I'll explain that to you when we see the photo. And we are also talking of vulnerable witness deposition centers, where victims of sexual offenses, in fear of deposing with the accused in the box, invariably turn what is called hostile in court. That is, they don't support the version of the events that they've given to the prosecution. We've made sure that these vulnerable witness deposition centers are set up where the victim is shielded from having to face the accused. They're sitting in separate chambers and linked through video, where the victim still does not have to see the accused, whereas vice versa is possible. Questions are administered to the victim through the judge, and from the judge to a helper who sits next, typically a child or a person of tender age, and communicated to that person of tender age in an easy language so that it's not like a rigorous cross-examination by a seasoned lawyer. We've also talked of judges getting access to journals like Supreme Court cases in soft copies. Of course, I've spoken about live streaming. We also have what is called a PIL portal. And one offshoot of this digitization project was that old records of the High Court of Odisha and the district courts, as old as 1808, were chanced upon. We have a separate project for scanning those old records, for first of all restoring them. I'll show you a small video clip on that. And this is what happened in the Odisha High Court. Now I'm going to take a small break, if Sandhya can help me, and play the video of the Record Room Digitization Center of the High Court of Odisha.
Record Room Digitization Center.
For those wondering what is Justice Chandrachud doing in this frame, he was present at the 1 year. We had a function for 1 year of completion of the record room, and he was there at that. He was present online, and we've taken this clip from the YouTube, and therefore he's there.
Where around 275 people, including High Court staffs, DEOs, scanning agency, and retired High Court staffs, are working for digitization of all disposed of civil and criminal records, and to essentially reduce the burden of storage of paper files in the High Court of Odisha. There are various stages which leads to digitization of disposed of records and finally to its shredding. Stage 1. Transportation of consigned records to RRDC. Disposed of civil and criminal records are kept in decree disposal and criminal disposal section respectively of the High Court of Odisha. The superintendents of the disposal sections send requests to the Assistant Registrar Administration on a daily basis for transportation of consigned records to RRDC. A staff of the disposal section monitors the process of transportation. In the initial stage, 11 lakh records were shifted from the High Court to RRDC within a period of 2 months. Stage 2. Receiving of records in the record room. Upon arrival of records in RRDC, the staff of the record rooms ensure immediate storage of the same in earmarked locations of the record room. The staff of record rooms check whether the record is complete in all aspects or not. The record room staff segregate the consigned records on the basis of date of disposal, and the bundles are then stored in ear-marked compactors chronologically, waiting for their turn to be digitized. Stage 3. Getting ready for scanning. Stacked bundles having case files are received from record room. Stage 4. Pre-process. Each file is assigned with a unique barcode for digital readability of the file. About 50 records makes a batch, and those batches are given a batch name for the work process of the scanning agency. Batches are sent chronologically as is received from respective record rooms. Stage 5. Ready for scanning. Files are made ready for scanning in the pre-process stage by removing pins, untangling and checking its durability for scanning. Stage 6. Scanning. Files having barcode are scanned in high-speed automatic document feeder, or better known as ADF scanners or book scanners according to their condition. Paper passes through the scanner. Meanwhile, in the system, such scanned images get captured after each page is scanned. The ADFs take images of both sides and in a minute completes scanning of 60 pages or 120 images of both sides. Files are then stored in the racks. Stage 7. Quality check (QC). In this process, blank pages and folded pages are removed and rectified. Further, alignment of tilted pages, removing spots, and smoothing of edges and many such processes are carried out to improve the quality of the scanned record. Stage 8. Indexing. In indexing or bookmarking, each scanned page is flagged according to the nature of its contents, which would enhance its searchable quotient. Stage 9. PDF generation and OCR. Each scanned page is converted to PDF or portable document format. Optical character recognition (OCR) enables all case files to be converted into searchable PDFs. Each PDF file is separated as per the indexing parameter like order sheet, annexer, judgment, etc. And then multi-page PDF is generated. Stage 10. Post-process. After scanning, records are tagged and added with a cover sheet which has brief details of the records. Stage 11. Metadata entry. Name of the judge, year of the institution of the case, case type, name of the petitioner, name of the respondent, barcode and other important information is fed in the system. Stage 12. Verification of scanned case records by verifiers. The data of each physical file are verified with the soft copy to ensure whether every bit of information is captured in the soft copy or not. A total of 10 and 8 numbers of verifiers are engaged on behalf of the court to verify the accuracy of scanning and metadata entry in scanned civil and criminal records respectively. The said 18 verifiers comprising of DEOs and retired High Court employees constitute the first layer of verification of scanned case records. Each scanned case records are then checked page by page with regard to various aspects of quality of scanning such as visibility, readability, availability of each page, proper sequencing of pages, etc. Moreover, the verifier also has to verify and check as to whether the metadata entries made by the scanning agency are accurate and at par with the information contained in the physical case records. If the verified record is found to have any error, it is then sent back to the scanning team to fix the glitch. If the verified record is found to be error-free in all the above aspects, then the verifier has to put the date of verification and his or her signature on the cover sheet attached to each scanning record. This step denotes that the concerned scanned case record is successfully verified and is free from all errors. After verification, the records are returned to the record rooms where the staffs check it and chronologically send it to the shredding office. Stage 13. Final step of digitization process. To strengthen the process of verification, a second layer of random verification is being carried out by the judicial officers working at the registry. Once a batch of case is approved by the judicial officers conducting random verification, it becomes accessible for general viewing in DMS. The last stage, stage 14, shredding. The shredding office works as a third layer of verification prior to shredding. After verifying the physical record, which tallies with the record in the DMS, and ensuring that the aforementioned metadata are available in their scanned formats in DMS and are accessible and retrievable, the shredding office sends those records to the shredding room for shredding. The shredded files are thereafter auctioned out.
So if you're wondering how this happened, we used the COVID times when there were days when courts would not function. I would gather my entire team. We actually tried this out on a small scale as a pilot in the High Court premises in one of the large halls. And we could then actually draw the entire flow chart, which will come first, which will come next, and how the file will move and all of that. Once we were clear that this was working, then we scaled it up when we went to the Record Room Digitisation Center. More than a year later, when we invited, I've not named the company, to tell us just one module of this, saying, can I know at the touch of a button whether the file using the barcode is in room A or room B or room C? They gave us a bill of 20 crores, and that was it. So we found that our homegrown solutions were far better than engaging an agency for this. Now, this has been replicated in all the district courts in Odisha. So we started in 4 major cities: Berhampur, of course Cuttack, Sambalpur, and Baleshwar in the north. And within a year, we could open 10 other digitization hubs in the district. Now, every district court has scanned papers. There are paperless courts. There are almost 200 paperless courts in the districts in Odisha today. And very soon, within a year, we'll have most of the courts, I think 70 to 80% of the Odisha courts being paperless. I just want to play it to you because this is a precursor to having paperless courts, which is, of course, scanning.
Working of paperless court. India has a multi-level court system. There has been a high backlog of cases in Indian courts over the years as a result of the court's growing workload. A significant portion of the delay is attributed to the cumbersome paperwork that makes up the foundation of the court system. As the years pass, the case file accumulates with the petitions, memos, documents and their copies, citations of case laws, etc., making it increasingly difficult to organize and requires more manpower and storage space. Moreover, the handwritten order sheets and depositions fade away with passage of time, making them illegible and hard to decipher. An innovative concept of paperless courts has been envisioned and tested in the Apex Court and different high courts to address these issues and to provide speedy justice. In a traditional court, case information is available to a judge through a case information system. A paperless court, as the name suggests, is a court that functions without the physical records, where judges rely on digitized court records and use technology for facilitating the court proceedings. A paperless court strives to modernize the work process of the judiciary by eliminating the need for physical records and the inherent liabilities associated with the storage congestion, risk of misplacing and retrieving documents. In a paperless court, the entire case record is available to a judge in a portable device, making it convenient to access the relevant part of the record without browsing through the entire file, thereby saving time and making the workflow more efficient. It also reduces work pressure on court staff from organizing the record chronologically. The process of digitization involves sending of case records as per cause list, pre-scanning procedure, scanning of case records, quality check of scanned pages, metadata entry, bookmarking of scanned pages under different heads for easy access, and finally, the integration of the scanned records with the cause list. The courts in Odisha have adopted e-filing 3.0. The litigants and advocates can file the cases through e-filing 3.0, and the said cases shall be directly consumed by the courts, thereby obviating the need of physical filing. The e-filing module has integrated the payment of e-court fees, which is not only economical but also environment friendly. The pre-trial procedures can be accelerated by utilizing the aforesaid paperless modes. During trial, the depositions of the witnesses can be recorded in paperless mode and their signatures can be obtained digitally, obviating the requirement of paper depositions. In paperless courts, it is very convenient for judges to have easy access to the bulky case records, which are segregated in different parts, and the relevant portions are available with a click on the bookmark. The touch screen devices enable the judges to take down notes and highlight portions of the pleadings and evidence found to be relevant during the course of arguments, which are of tremendous use while preparing orders or judgments. Judicial officers in Odisha have been given subscription of SCC Online. Now, in the paperless court, they can access the same on the Wacom right on the dais, which will help them in referring to the decisions of the Honorable Supreme Court and High Court. In the first phase of e-courts project, we had CIS, through which we could get the certain information of the case at the click of a button, and now through the paperless court, since the whole record is digitized, the entire case record will be available literally at our fingertips. A paperless court which is not only economical but also environment friendly.
So among the other things that's happened is, fortunately, my succeeding Chief Justices have continued with this paperless courts. And perhaps Odisha is the only state in the entire country where paperless courts have been introduced in the district courts. I think Kerala is now attempting to do it. And it's the other state in the country which is doing it. This is doable, and it's proving to be very useful for our judicial officers. Like I said, you saw even in the video, the lawyer is still arguing from a paper file, whereas the judge is able to operate in a paperless mode. There are several things that I have to say about Odisha, which time doesn't permit me to. So I'll just quickly run through all of this. I just wanted to share with you the Center for Judicial Archives, which is an outcome of the digitization process itself. That which you saw was the paperless court in the High Court, which was my court, and now I have 10 other benches in the High Court, which is paperless. I don't have time to explain to you the judicial workflow automation system. All the non-judicial branches in the High Court are now completely paperless and operating through this system. We've had it customized for the High Court. Again, the only High Court in the entire country where the administrative side of the High Court is functioning in paperless mode. E-filing I've spoken about, e-inspection I've spoken about, e-payment, uploading of orders and judgments. You actually get digitally signed orders on the net so that you don't have to wait to get a certified copy in the court. And the hybrid system, I think I've spoken about. These virtual courts I just wanted to briefly tell you about, because a trial can get delayed if the doctor who has to depose in a government hospital has to leave his entire work and wait in the court for a whole day. Likewise, an investigating officer who may have retired from service, staying now in a different city, for him to come to the court and depose takes time. So likewise, the forensic sciences man. So people in different locations can now depose from wherever they are. There's a visualizer in the court, which then shows the document to the person and is able to depose. The lawyer in the court, of course, the defense lawyer will be able to cross-examine them. Entire thing works in a paperless mode. And judges in Odisha have been able to schedule hearings. They tell the doctor, you have to depose at 3 p.m. on 24th October. The doctor doesn't have to wait the whole day. At 3 p.m., he switches on his camera on his system and is able to depose online. We have remote controllers who ensure that the person deposing from a remote location is doing it without any fear or intimidation. So that is one thing. And then we now have benches of the Odisha High Court in virtually every district. So this demand for separate benches by lawyers, including in Karnataka, when they had the benches in Dharwad and Kaluburgi, those kind of demands could have easily been met if we had given them virtual courts without people having to travel to those places. Now this is a solution that is available even to the Supreme Court of India, where there are demands for regional benches of the Supreme Court. Today, literally sitting in Bangalore, you can appear before the Supreme Court, you can e-file your case, you can argue your case, and it's right now happening. If people have been watching the live streaming of Supreme Court proceedings, you have lawyers appearing from various locations in the Supreme Court. Vulnerable witness deposition centers have spoken about, e-libraries for advocates. I'll just end with showing you the Center for Judicial Archives. The training we've provided are hands-on training, where my judicial officer, who's a master trainer, sits next to the advocate, helps them hold a mouse, click on buttons, teaches them e-filing by literally sitting next to the advocate. So I'll just end my presentation with this video on the Center for Judicial Archives.
All disposed of records of the High Court of Odisha are now being preserved in Record Room Digitisation Centre. With the help of INTAC, the preservation work is progressing at a rapid pace. The degradation of paper material depends on the quality of the paper and various other inherent and external factors. Among the most noticeable deterioration,
for you to understand, Odisha was controlled by the Mughals and then the Marathas. The northern part of Odisha was part of the Bengal presidency. The southern part was part of the Madras presidency. So you have judgments, of course, in Bengali, you have in Telugu, you have in Farsi. We get these judgments in Farsi translated by a professor in Ashoka University in Delhi. And so you have multiple languages among these old records, and what you're seeing is 200-year-old records.
that is recognized during the course of this examination are the following: acidic and brittle pages, tears, cuts and losses, stains, damaged spines, creases and folds, softening of paper, previous insect attack damage, damaged binding, stuck folios or pages, bleeding or smudging of ink or color. Unless treated in time, this deterioration could reach such a stage when a large part of the collection could be lost forever. Conservation procedure: documentation of the record, dry brushing of individual record, chemical and physical examination of record, fumigation of records or pages. The records are fumigated for at least a week inside fumigation chamber with appropriate fumigants like paradichlorobenzene and thymol crystals. Chemical conservation, consolidation and fixing of running inks. Aqueous deacidification in case of sheets having non-soluble inks. Double-sided lining with good quality tissue papers to impart physical strength to the record when they are in extremely fragile condition. Stitching and binding of the guarded and lined sheets with conservation guidelines. These conservation interventions, when carried out on a fragile record, enhances the lifespan of the record when preserved in controlled climate and technical guidance. For purpose of exclusive plan, the High Court of...
This is a separate building, it's going to be called the Center for Judicial Archives. Hopefully, beginning of next year, it should be ready. It will hold not only the old records of the High Court and the Cuttack District Court, but other district courts as well. Actually, I'm running short of time, so no more videos are possible. I just will end with showing you the photographs of how we focused on, there's a Museum of Justice in Cuttack, which was an outcome of this whole digitization exercise. We've traced the entire judicial history of just one state, which is Odisha. We've showcased some of these documents which were preserved of the old records. So what you see on the left is how a record room was before I came there and now how it is. What you see on the left is the registry as it was. What you see on the right is when I left. And this is how I think the employees in Odisha felt that they were now working for an institution. Thank you. Thank you.
Thanks a lot, Justice Muralidhar, for that very enlightening discussion on technology in Indian courts and specifically the initiatives in the Odisha High Court. I had travelled to Odisha about 1.5 years or so back, and I had seen the record digitisation centre and the process of preservation of old records. And as a history buff, it was really exciting for me. I think there are several PhDs and several books to be written from the records that have been preserved there. We'll now move on to the audience Q&A section. I'd like to invite Harish Narsappa from Daksh to moderate the discussion.
Thank you, Justice Muralidhar, for that insightful talk. See, I think when we announced that Justice Muralidhar was going to deliver this year's lecture, and then the topic was announced, I think several people asked, why? I mean, you should have asked him to speak about one of the substantive law issues. Then I remember having this conversation with a friend, and I said, no, one of the best kept secrets about Justice Muralidhar is the amount of work that he has done outside of the substantive law, work. Because people only recognize judges for the judgments they write. But there are very few judges who contribute to the move of the institution and the functioning of the institution. And since Daksh has been working on the sort of non-substantive side, trying to see how we can strengthen the institution, we thought it's interesting and useful to understand the challenges that judiciary faces. Because we all complain about, they're slow, they're, whatever. I mean, we should not focus on the complaints, but focus on the challenges and the steps that we have, that many judges are taking. And that's why we thought, we need to hear this, because as Leah mentioned, and I'm going to talk for a minute just to give Justice Muralidhar a break so he can recover from the questions and comments that will come. See, constitutional ideals is not achieved by talking at 35,000 feet, right? There are many small steps. And the critical institution in the safeguarding of the ideals is the judiciary. And unless we make the judiciary work better, I won't use the word efficient because I don't accept that they're inefficient now. We can make them work better. So, and that happens step by step. And we can only take the example of Google. Google was not built in a day, right? The amount of hard work that that has gone into the usage of the map that we all like is something we won't know. I'm sure many technicians will know, but that is a challenge with achieving the ideals and building an institution. And that's why we wanted to showcase this and learn from what a few judges across the country are doing and have been able to achieve. And Odisha is one of the examples. And the Daksh team had the privilege of coming and visiting, the record room and a few districts and the amount of work that had gone. So we will take a few questions. May request questions literally to be questions and not sort of comments. If you can, come up to the mic. I think we have a mic. That's the BIC protocol, so then they can record the person asking the question as well, and the question gets recorded properly. And then, if we request you to keep the question brief, so that it gives an opportunity to take, maybe 5 to 10 questions in about 20 minutes that we have. Okay. Yes, sir. Please raise your hand so that I can see. Okay. So first you and then Carl.
Brilliant presentation, sir. Thank you very much. I don't have a legal background, but I have a question on this matter of bail, in the sense that while Supreme Court has said that bail is a rule and jail is exceptional situation, in spite of that, things like people like Varavara Rao and Stan Swami, and recently even somebody who was denied a bail after 5 years. If this is the situation, also there is a very scandalous situation under trials in the whole country. What can the computerization do to kind of speed up this process or bring in some sense of automaticity wherein things are just getting disposed of facelessly, just like it happens in income tax refunds? Thank you.
Okay.
Justice Muralidhar, that was brilliant. I have a quick technical question. Between stages 1, acquisition, and 11, shredding, do you know how many pages you scanned, and do you know how much your cost per page was?
Yeah. Okay. Sort that out. Yeah.
Thank you so much. My question is, Justice, did you face any rights-based concerns while you were, rights-based concerns? Be it right to privacy or access to justice, if you could just elucidate on that. Thank you.
Okay. So,
As far as the first question is concerned, computerization of courts will not ensure that more bails are granted than less. We have very harsh laws in this country. The two instances you're mentioning, Father Stan Swami and Varavara Rao, were both taken in under the Unlawful Activities Prevention Act. And it follows a certain template of statutes which make the granting of bail nearly impossible. It shifts the burden of showing your innocence on the person who's accused. So it's such a huge thing to cross. And it's the courts that have to do. Merely because you place a computer before the court or a screen, Wacom monitor, it doesn't mean that the court is going to react differently. So I think that what computerization can do is tell us how many under trials are actually awaiting release, and what is the pendency in courts, what is the pace at which bail applications are disposed of, how courts compare in disposal of bail applications. So it can give you data analysis to help the judge understand the importance of the case that the judge is dealing with and prioritize some of these cases. Like typically when we talk of criminal appeals in the Odisha High Court, and not just the Odisha High Court, certain other high courts as well, we would prioritize the criminal appeals of persons in custody as compared to criminal appeals of persons who are out on bail. So it does help. Data does help us understand why certain cases have to be fast-tracked over others. But that's again up to each judge and each court to make use of the data which is there with them and want to make use of it. So it is largely depending on the judge and on the lawyers too. We somehow don't seem to focus enough on the role of lawyers in all these exercises. And they have a major role to play, and I hope both will see how useful some of this analysis can be for their own functioning. Carl, to answer your question, I think more than 4 or 5 crore pages have already been scanned, and it could be much higher now. And cost per page was around 40 paise per page up to the stage of shredding. But again, that could go down with economies of scale. And I must also mention, some people get alarmed when they see shredding, because shredding means it's lost forever, right? It can't be reconstructed. But with the levels of verification that we showed on the screen, it's possible to reconstruct the file and make it even more readable. And it is certified digitally by a responsible officer of the court that it is a complete reproduction of the file. And again, we are picking up files where they are filed in large numbers, like writ petitions and bail applications. And we have a different protocol for shredding of files which contain sensitive documents like sale deeds, wills. This can never be shredded. So we pull them out of the shredded file and put them in a cover. So it's preserved for eternity. So that is something that I wish to share with all of you. We developed several protocols. We amend the rules in the High Court to reduce the holding time for different types of cases. A lot of thought has gone into it. A lot of debate among the judges has gone into it. Rights-based concerns, yes. See, one straight example that comes to me for which there are petitions pending in the Delhi High Court. Let's take a case under Section 498A IPC. For those who are non-lawyers, this is a provision for cruelty, which makes cruelty to the wife within 7 years of marriage a punishable offense. And usually, persons involved in this case would not be limited to the husband, but to relatives of the husband, including the brothers-in-law, sisters-in-law, and of course the father and mother-in-law, who could be in different locations. When the judgment is written, even though a judge may be sensitive and not disclose the name of the victim, and maybe, because the name of the accused appears in the cause title itself, the names of all the others could be disclosed in the judgment while discussing their roles. And this is uploaded, the judgment is uploaded. And it's there for the whole world to see. And you Google the name of this person who has applied in your organization for a job, and you find that he was involved in a case. Despite his acquittal, you say, no, let us not have a person who has been involved in a criminal case. So it can really mar your chances, although you've got a clean acquittal in a criminal case. Likewise, various categories of cases. Now, all these records are available on the net for the last 20 years. And how do you clean up the entire record to remove all these names? So we do need to develop protocols where we respect the privacy, protect the privacy of persons involved in cases. And I don't think enough thought has gone into it. We need to have actually an active debate. This is one of the rights concerns on privacy, but there are many others. There's not time to discuss that. I think that's a whole session by itself.
Yeah. Okay, so, yeah. So first, the gentleman in the blue, yeah. You, then Aruna, and then three,
yeah.
In that order. Yeah.
Thank you, Justice Muralidhar. It was really an enlightening session. I want to know, in the third phase, there is a lot of talk these days happening on the AI, and there's a lot of this thing that is being talked about, that there can be a more intuitive, not intuitive, a computer-generated direction can be given to the lawyer or to the judges also. Is there anything that is planned in phase 3 of this program?
No, phase 3 actually talks. Yeah. Phase 3 actually talks of market players using AI to develop solutions from the entire data that's put out. Of course, I think there are other judges also who express caution. I would join them in expressing extreme caution on using AI, because if it gets it wrong, it can get it terribly wrong. So, and it can be irreversible, some of these mistakes. And we're dealing with human lives, and we need to be very conscious of this. I think AI should be completely kept out of anything to do with actual judicial functioning. There's no doubt about that at all. And even for analysis of data and developing algorithms, I think we need to be very careful. Even in other fields, we are finding that it's actually problematic rather than finding safe solutions. So I think we have to be very cautious about what we mean when we say use of AI. Like ChatGPT is already causing enough problems. And so there needs to be much more open debate on this before we even go in that way. Yeah.
Yeah. So Aruna, and then the person there, and then the next set I'll come 1, 2, 3. Okay.
Thank you. Thank you, sir, for your great interaction today and all the initiative that you are taking, that you have taken in your court. The quick question I had was about, I'm just curious, was there also discussion about having systems which, having these kind of electronic and electronic infrastructure in other systems that the court interacts with, that is, let's say, the forensic science laboratory or the hospitals and the I know there's something for prisons, but I don't know how effective that is. But was there a discussion about having a seamless structure?
No. Actually, I couldn't have time to discuss. We have something called the e-custody certificate. Typically, when an application is filed for a grant of bail, the High Court judge wants to know the person's involvement previously in criminal cases and what was the outcome of those cases and whether the person is out on bail in those cases. So the entire history of the person's involvement in cases needs to be told to the judge. Usually a lot of time is taken by the prosecutor to elicit this information. So in Haryana, they developed this e-custody certificate, which on the very first hearing of the case could be available to the judge, who would know, like a dashboard, what the previous involvement of the man was in criminal cases. And helps the judge decide whether bail should be granted or not to be granted. So that was one interaction with prison systems and the police systems. And there's a talk of integrated criminal justice system and interoperable criminal justice system, which the Vision 3 document talks about. But we need to be careful again about the fidelity of data, that how accurate is the data and how prompt it is. And accuracy of data is a concern that all of these people preparing these reports have also expressed. And in the past also, there's been a big problem in the way we enter data. The problem with all these technology systems is if the input is erroneous, the output is bound to be erroneous. So we have to make sure that like spelling mistakes are not made. So there could be two Sanjay Kumars in a prison. And if you don't know to distinguish one from the other, great miscarriage of justice can happen. So, yeah.
Thank you, Justice, for painting a very positive impression about Odisha. And I heard that the in-house solution was very cheap whereas compared to for the digitization process. Since you told that this started off from 2020, I have one question. You stated that a new Judiciary Technology Council was formed.
No, I didn't say that. There's no new Judicial Technology Council. I think you're mixing up with the Vision 3 document, which recommends the forming of such a Judicial Technology Council. We didn't have time to discuss all that. No, there's no such thing in Odisha.
And to make this happen, you said that you had some lawyers or judicial people who
no, only judicial officers. Yeah, I must acknowledge here, every High Court you have what is called a Central Project Coordinator, a CPC. And he's a judicial officer. And Odisha is very fortunate to have extremely bright and talented CPCs. And I must mention Arun Patra, who was my CPC in the first year, and now Satyaprakash Roy Chaudhary, who's the CPC of the High Court now. Both were completely hands-on, fully alive to all the latest developments, also conscious of safety and security concerns. So I must tell you that we invited experts to audit our systems, security audit. And the man went back saying that I'm going to use this as the template for audit of all other high courts. So we felt assured that we were on the right path. So we were very conscious of all those things, and we had very talented young officers. Even the volunteers for these paperless courts, I only sought volunteers. There's no question of compelling a judicial officer to become paperless. And readily they volunteered. And that's how we've been able to have 250 paperless courts in Odisha today.
Awesome then.
Actually, the point I think many people are missing is asking for paperless courts in Supreme Court and High Courts, but the judges are younger in the district courts.
Exactly.
So somehow I think
that's missed. In fact, I've always said every new batch of judicial officers in the Judicial Academy itself, they're trained on paperless courts, which we are doing in Odisha. So when they come and first sit in court, we can easily give them a monitor and say, start holding paperless court, and they'll happily do it. So this was a small thing which I think can be replicated anywhere in the country.
Yeah. Okay. First you, then Naren, and then...
Thank you. To do all of this, I'm sure that you need lots of money. So I was wondering if the judiciary has a fund of its own, why go to the central government every time? Or is there any work being done upon this?
No, the judiciary never has money of its own, sir. In fact, the point is this, there are documented studies to show that the court fees that the litigants pay far exceeds the budget allocated for the judiciary. So all the governments are they have huge funds contributed by tax-paying citizens and litigants, and not even a small percentage is spent on the judiciary. That's point number one. Point number two, if the central government and the state government give you 100 rupees, and if you don't spend 40 rupees, why would they give you 200 rupees the next time, right? So some part of the reason is the inability of the court to spend what is given to it. But the real reason, further reasons, is the inefficiency of the system itself. We typically have a March syndrome, where by the time January happens, you're in panic to spend the money. And the money meant to be spent for the entire year is released to you only in November or December. How are you supposed to spend it within 2 months? So all these are typical problems of government departments, which gets extended to the judiciary also. But what I found in Odisha is, I knew how to spend 100 out of 100 rupees. So when I went back, when the government suddenly woke up and said, who's this in your court? What is this happening? And they were very happy giving 200 for the next year, 300 for the third year. You wouldn't believe, by the time I left, we give 1,000 crore budget to the Odisha government. They're very happy receiving it, because that's the scale of changes and transformation that we're looking in Odisha, not just for technology, infrastructure as well. We have state-of-the-art judicial complexes in most districts in Odisha. So, and it's all about this, how you respond to the task. But it's unfair, I think, to expect judges all over the country to, somehow find the right way to spend monies and all. This is not their major concern. The Vision 3.0 document also acknowledges it. We probably need specialized, inputs from experts, but they should be within the judiciary itself. I have a concern with when some, external agencies coming in, using the data and trying to have solutions where we become their clients. We don't want that kind of a model at all. I think that's the wrong way to go.
Honored to ask this question, Your Lordship. So the vision document...
No, Lordship. Even when I was sitting in court, I said no to Lordship.
Sorry. I'm learning how to say that, so I tried it here. I'm an engineer by training.
No.
My question is, my understanding is that the vision document had no section on RTI. So in a digital world, the RTI is very different than what was enacted in 2000 for paper copies. As far as I'm concerned, Constitution is a design to constrain the forces. So is data. So my question is, why is Supreme Court not starting the process? Because this process of RTI 2.0 needs to extend to executive and perhaps even the legislature. My question is it noticed or is it something?
No, it's certainly noticed. I think there's no question of not noticing. It's not knowing how to go about it. I think we are basically a conservative institution.
If it's not knowing, I must say, compared to the kind of complex things you talked about, it's extremely simple. You just let the software programmers record the data and make it processable. It's very simple for a computer programmer, 200%. There's no question about it. No. The question is whether the authority is using its position to constrain that. I'm sorry, I shouldn't start that.
No, it's a good question. Actually, it is a very good question. In fact, the Vision 3.0 talks of a set of core values. Part of it was transparency, accountability, and all of that. Now, it's all good on paper, right? When it actually comes to look at one thing of disclosure of assets by judges, right? It ran into there was a resistance to acknowledging that the office of the Chief Justice is a public authority for the purposes of RTI. So it required a High Court judgment of the Delhi High Court, affirmed, in somewhat same tenor, but maybe in a diluted form by the Supreme Court many years later. This conservatism that we have, we need to shed that. But there's a whole bureaucracy working to frustrate the RTI Act. I think you should be aware of that. And it is a struggle, but we have to move towards greater transparency. There can be no doubt at all about that.
So, Murali, 2022, we were there and fantastic, really zapped. Now, two questions. Odisha being particularly, your state and so much of a tribal and poorer population, where there are concerns about the digital divide, where the courts move more digital, where those issues are a challenge. That's one. Second is that the second question I had more to do with in terms of impact assessment, were you able to say that the pendency of cases came down by X%, more judgments were issued? I'm just interested to know a bit about that.
Yeah, let me take the second question first on the impact assessment. I wouldn't say technology by itself brought about a reduction in the number of cases. After all, technology is just a tool. All right, it helped us focus on which kinds of cases we should, fast track. I mentioned to you about the lower court records, right? With technology, we could make sure that we digitize all the lower court records in our court and send it back so that the cases in the trial courts could progress. That way, the old cases, the 30-year-old cases, 25-year-old cases, we could see a remarkable drop. But that was because I was having monthly meetings with judges. And district judges heading the districts could have fortnightly meetings with those individual judges. And there was a reporting back mechanism. I would have virtual meetings literally with judges, and we would closely monitor the figures of old cases. But technology helped in that. Once they knew that I was having an interaction with them on these old cases every month, they had to be ready with it. They, in turn, would have interaction with their judges. So we have to put in place systems where technology will be the tool which helps us monitor the progress. And that way, pendency did come down. We had a pendency of 2 lakh cases in Odisha when I took over. It came down to 1,50,000 by the time I left. So it was a clear distinction in drop in number of cases and acceleration of disposal of some chronic cases which had been plaguing the system for many, many years.
Yeah.
Sorry, there was one more question on digital divide. So what we do is that we don't make a overnight transition of systems at all. It's always incremental. So we tell the lawyer you can have a physical copy. We will make a digital. We'll give you a free copy of the digital. So that way the lawyer is not hamstrung because he doesn't have a smartphone or a computer. Second, we have e-seva kendras in all the district courts, even the subordinate outlying stations, where you can go and operate the system there and do your e-filing and those kind of things. So there's a hand-holding that happens so that lawyers who don't have these systems do not suffer for that.
Please.
Thank you, Justice. This was such an interesting talk. I have two questions. My first question is that I think, if you look at like the video, right, you see a lot of the documents that have been, like restored, a lot of them, if they are, around like 100 or like 200 odd years old, then how important and, like relevant are these today? And my second question is, even though space is a concern, if you look at, like our paper, like our documents, even on the online cloud, right, space still continues to be a concern. So I was wondering if, as we scale up, is looking at, the online space another, like a concern or like something that we are thinking about? Yeah.
You'll be interested to note, I was having a conversation with Carl just before we started the talk. Carl Malamud is a real expert, and he assured me that there's actually no shortage of virtual space yet. So there's enough to accommodate all, because I was asking in the context of live streaming of hearings, right? Live streaming is a recent phenomenon, and all of us are hosting it on YouTube, and YouTube is owned by a private entity, right? So how safe are all these live streaming hearings on some YouTube platform? And I was asking him, is it possible for the judiciary to have its own platform where it will host all? And he said, of course it is possible, and it's all economically feasible. For something like 10 lakhs of rupees, he said you can have some tetrabytes or whatever bytes, terabytes. So I'm just saying it's a doable thing. Space is not a constraint. In relevance, we had the first ever national conference on judicial history in Odisha in May this year, where historians came. And they were blown by the Center for Judicial Archives. From pure legal history, there's a whole phenomenon, a phase prior to 1860. I don't know if you're a law person. 1860, when the Indian Penal Code was enacted, right? 1872 was when the Indian Contract Act and Indian Evidence Act were enacted. You have a whole phase of 7 decades or 6 decades before these statutes came about, and courts were dealing with all these issues. So how was a murder case tried in 1810? How was it tried in 1820? How was a breach of contract dealt with in Odisha in 1830? It's actually mind-blowing for the legal historian. How laws developed, how did we transition from customary law to statute law? So you have numerous questions. The historians are very excited about this possibility. I've in fact spoken to the CJI on several occasions why this should be scaled up to a national judicial history project. And these records will contain numerous, facts which can help us fact check. Because today history has become a very contentious, discipline. And judicial records will probably set right many of the claims that we make in history. So I think it's very important to see how societies lived. Yeah, I don't know if you heard the name Ranajit Guha. The subaltern studies. This is in a sense subaltern. People of those societies in Odisha, some villager in Ganjam district in 1850. What problem did he have? What were the issues? How was witnesses treated? I think it will be mind-blowing for sociologists too. We just have a treasure here which we haven't tapped into, and I think it's high time we did it.
So I have 2 questions.
One. You said it was a follow-up. Anyway, one. Yeah.
It was a follow-up, primarily on court fee. We understand it's a court fee that we pay, but what is the reciprocal service? The faster, the easy disposal, or
so where else in the world do lawyers get free soft copies of their own cases? Where else are lawyers permitted to argue from whichever corner of a state? And I'm saying there are so many services now uncalled for by the lawyers. Lawyers have not demanded these things, but they're being given all of that. Just for ease of use of court, simultaneously today, 10 years ago, you were running between the DRT and the High Court and the Civil Court, correct?
Yes, yes.
Today, sitting in your chamber, you can appear in all three?
I think
that is vis-a-vis.
the spirit was for the litigant.
Litigant,
So if
not
you're
for
paying
the-
a court fee and your case doesn't get resolved in 10 years, I think that's the spirit.
Yeah, so you should ask lawyers also, not just judges, what is their role in making sure cases don't progress? Today, sir, it's a fact. A criminal appeal is called out in the Supreme Court. Very often, lawyers do not appear. And the case cannot be dismissed because it's somebody's life which is at stake. An old civil appeal is called out. I'm talking of the Supreme Court. It's an equal scenario in all the high courts. You will be watching for that. So we shouldn't underestimate the role of a lawyer. There are judges and judges waiting to hear and dispose of cases, lawyers not prepared to argue the cases. So we should talk about that as well. I'm sure there are judges who do not sit the full day, who are reluctant to hear cases, but it's both ways. So we haven't done that thorough analysis, and I'm sorry to say that even these documents, these vision documents, don't account for the role of the lawyer.
Very good. Thanks.
Okay. Akash and then...
Hi, good evening, sir. So my question actually related to your last statement, that all these vision documents, do they envisage access to lawyers for the pleadings?
Yes, they do, of course. In fact, all your e-inspection centers and all that, you can inspect documents in your case, definitely.
But like the judicial officers have been given an opportunity to access the entire record at ease.
You're getting a free copy, sir. The lawyer will have to just produce his pen drive. The court gives him the entire copy of his own file on a pen drive.
Okay, sir, that's great, but I think the lawyer should be put at equal power where they get access to all the software systems that judicial officers are accessing with all the bookmarking.
No, you are getting a bookmark file, sir. Let me just explain to you. The bookmarking is done by the high courts or the district courts. If the lawyer wants, saying that let me get a same copy of a bookmark file from you, the court is today giving it to him free. And that's because people like me insisted that to incentivize, we should give it free. Some of the judges said, why should they get it for free? Why don't they pay some token amount at least? I said, no, till the system gets, properly streamlined, let's give it to them for free. So in Delhi High Court, at least for the last 10 years, lawyers have been getting documents of running to 10,000, sometimes 20,000 pages, free of cost, fully bookmarked.
No.
Lawyers should come forward to take it.
I think we can only hope for the acceleration of the process with other states and high courts.
No, but we must talk to lawyers. I'm saying we have to talk to the bar councils and bar associations to ask them what is stopping them from embracing it. So in Odisha, I made sure that we had training sessions for lawyers. So lawyers not only in the High Court, but lawyers in the district courts, and importantly, lawyers, clerks.
Yes.
So we included clerks as part of that system and made sure that all of them received training.
Okay, last question.
Thank you, sir.
Good evening, sir. I believe this legal thing is a very closed community. And when do you think, suppose a general person, as a citizen, let's say a woman suffering from domestic violence or something, in her comfort of her home, bring the issue to the court through online, through the development of technology. And the background work which needs to be done legally will be done legally. Ecosystem develops to such a situation.
Yeah, one is we increase awareness of the availability of legal services. Your point is absolutely valid, sir. Today, there's very little awareness that you can go to a legal services authority at the taluk level, district level, to seek help.
Yes.
They should have the wherewithal to go to this e-seva kendras. Usually these legal service authorities are within the district court complex itself. So they can help the woman file through those e-seva kendras online, even though she may not have a mobile phone or a system or whatever. That hand-holding can be done by the legal services authority at that level. And they can have paralegal volunteers. So there is, in the system, all of this is made available. How well it is operated in different districts varies. Because it again depends on individuals, the vision of such individuals, they're wanting the system to work. So it is there. I'm saying it's there for us to use. We can only hope they use all these facilities to make sure a woman like that is able to use these facilities.
Yes. And when do you think it can...
Thank you.
No,
thank you. No, thank you.
Thank you.
I have a last question for you. How do we institutionalize this effort? For example, we were discussing briefly before the talk as well. Now, currently, the initiative seems to be with each Chief Justice.
Yes.
And there's no ownership within the system. There's no office that owns, either the technology or the movement of technology or the use of technology in a widespread fashion. So how do we institutionalize this to make sure that the Odisha experiment either is not limited in time and with office of a particular individual and does not get limited to Odisha?
No, one is, since it's centralized everything in the E-committee, the E-committee can definitely mandate targets for transition. Saying like if they roll out an e-filing 4.0, they can make sure that each court, each high court and through the high courts, district court comes on that platform and has the e-filing done on that platform. And you can definitely monitor the progress. And there's a system of reporting back all that is possible. And from the high court to the district courts. So somewhere there's already in place a system. We produced annual reports. You know that every year we bring out an annual report. It has all the information on how we went about this entire process. And there's an institutional memory we create by having younger judges as part of the computer committee. So when the older judges move on, the younger judges will take over, and that's how we keep the continuity going. We also change the rules, and this is something that people miss out. The rules governing the functioning of the High Court. So I made sure that we changed those rules to incorporate in the rules all this e-filing, preserving of records, digital records, recognition of digital records, so that that's not tampered with. So that becomes part of the functioning of that system itself, irrespective of who the Chief Justice might be. So there are those kind of techniques that you use to give continuity. Ultimately, it will depend on individuals.
So we should just hope for more pollination and...
That's right. And memory. Like somebody will say, oh, when this person was Chief Justice, this happened. This is how they did it. These younger judicial officers, I talked to you of the 2 CPCs. One day they'll become district judges. Hopefully they'll become High Court judges. They'll carry with them a memory of doing all of this. In fact, the High Court employees, all of those who were involved in this entire exercise, and it could not have been possible without all of their involvement, they will all carry those memories of that we did it. We made it work. And that's what I kept telling them. You did it, you made it work, you carry this memory, you tell the next generation that it is possible. And that's how an institution grows.
Okay.
A big thanks to Justice Muralidhar for this great lecture. I'll keep my vote of thanks very short. I'd like to thank BIC for providing this venue. Great staff. We always have a very good experience when we have events here. Big thanks to my team at Daksh for organizing this, and all of you for being a great audience, distracting yourself from the chocolate festival and coming and spending time here. Thanks again. Have a nice evening.